DUI cases can be extremely serious and have to be handled that way. The penalties that are associated with DUI have gotten stiffer and stiffer every single year since I've practiced law for the last 15 years. The minimum mandatories for second and third DUIs have gone up to include mandatory jail sentences, and even for first-time offenders where there's no accident, the penalties can be pretty severe. So setting aside the impact that it has on your driving record, on your car insurance, the court penalties and the effects on the driver's license can be very serious. So DUI cases should really be aggressively defended so that the consequences are minimized. First of all, I want to talk a little bit about the effects of your driver's license. Obviously, if you're viewing this, you probably already have been arrested for a DUI. If you refuse to take your breath test, that pretty much automatically gives you a fairly good case to defend in court, but the consequences are harsher on your driver's license. What they probably have done is confiscated your license and told you that they're suspending it for your refusal to take the breath test. Even if you did take the breath test, if you blew over the so-called legal limit of .08, they still suspended your license and probably confiscated it from you. It's important that you really have two different cases going on at one time. You have a DUI case and a driver's license case, and it's important that you appeal this license suspension, whether it's for a refusal or for a breath test, within the 10 days time period, the 10-day window they give you after your arrest. Once you file for that appeal, which of course we would do for you as any lawyer would do, once you file for that appeal, the DMV will issue a 6-week permit that will enable you to at least drive for 6 weeks until you have your hearing. These DMV hearings are conducted by us, by attorneys. Typically, I would not have my client appear. I can handle it. And we're looking to get your license suspension overturned and get you your regular driver's license back. Again, this is a hearing that's completely separate from your court case and has nothing to do with really of whether you're guilty or innocent of a DUI. Mostly the ways that we get people's driver's licenses are on technicalities or other legal issues that I can explain to you when you come in. As far as your court case goes, you have two options. Of course, you can go in without an attorney and you can plead guilty and accept whatever the state is going to give you, or you can hire an attorney. A lot of people choose maybe not to hire an attorney because they don't think they have a valid legal defense. Maybe they took the breath test and they're over the limit, or they did poorly on the sobriety test. And I would caution you that does not necessarily mean you don't have a good defense. Hundreds and hundreds of breath test results in this area have been thrown out over the years on legal defenses and problems with the machine, problems with the source coding. So many different ways. There are so many different ways to fight a breath test DUI that you shouldn't just automatically assume that you can't defend the case. Obviously, as I said, anybody who refuses to take a breath test immediately has a good defense because one of the state's strongest pieces of evidence against you has gone away or has not been made available to them. As far as the sobriety test, the roadside sobriety test, look, I've tried hundreds of DUI cases. I tell people don't worry about doing those tests perfectly. The officers worry about that, but you shouldn't because jurors don't. A lot of those exercises they have you perform are very difficult for somebody to do, even if they're in great shape and completely sober, and juries understand that. So as long as you weren't completely slurring your words, fall down drunk, etc., most likely you shouldn't be very concerned about how you did on the sobriety tests. The steps to a criminal case are this. If you hire an attorney, the attorney goes to your initial court date for you. We go to your arraignment date, which is the first court date they've given you, and we demand discovery. What that means is that the state is required 20 days after your initial court date to turn over all the evidence that they have against you, whether it's a video, police reports, a witness list, whatever they have to turn over to us. It's when we get that stuff in is when we have you come in, and I have you come into my office and sit down and we go over all that and see where you stand. So that's kind of the way a criminal case kind of plays out. What we always try to do in every DUI case is negotiate with the state, try to get them to lower the charge to a lesser charge, such as reckless or careless driving. The state will do that in a certain percentage of cases, and a lot of it depends on how strong your case is. If you've got a good case, we're going to argue very aggressively. I'm going to be pushing for at least a reckless driving. The state may want some of the DUI penalties associated with it, but the good thing is that reckless driving, for example, is 4 points on your license. That's a lot better than getting a DUI on your driving record. So that's what we always try to do. Of course, a lot of DUI cases end up in a trial with a jury. Not most, but some. And if that's the case, you want somebody who's pretty experienced in front of a jury. As I said, I've tried hundreds of DUI cases. I've won over 90% of my DUI trials. You want a lawyer who's not only good with the law and who's good at arguing technical legal motions, but one that's good in front of a jury in a DUI case. And being solid in front of a jury also gives you more leverage. When you have an attorney who's a good trial lawyer, it also helps in negotiating a favorable disposition with the state attorney. As I said, if you have a second or third DUI, your case is a lot more serious. The state most likely is going to want a significant amount of county jail time associated with your case, but there's a lot of ways around it. There is a new DUI court in Sarasota County and Manatee County, and several other jurisdictions have these new DUI courts, and they're designed for second or third offenders. And it is a way to avoid having to do a jail sentence or to minimize that jail sentence so it can be served on weekends or something like that. And that's if you really don't have much of a defense and you have a second or third DUI and the consequences are severe and you're just looking to stay out of jail, there are ways to do that. As far as my fees go, my fees for DUIs are very reasonable compared to other attorneys with even a lot less experience than I do. And again, that's because I never want to lose a client over money if at all possible. The fees are, if you just have a standard minimum first DUI with no accident, they're very reasonable. The fees go up if you have a second or third DUI because the consequences of the case are a lot more severe and they're generally a lot more work. So we can discuss your case, discuss your fees, but the first initial consultation when you come in and talk to me about your DUI case is free. As far as if you have traffic tickets, if you have speeding tickets or any kind of other civil infraction that's not DUI related, we do have traffic court here in Sarasota where a magistrate will hear your tickets, and in most cases, unless your driving record is really, really bad in the last 5 years, the traffic court magistrate will agree to withhold adjudication. I can go into court and represent you where you don't have to appear. And what that does is it keeps it off your driving record for insurance purposes. You don't get the points. You probably still will have to pay the fine. If you do have a worse driving record or a lot of recent tickets, it's possible that the judge will order you to do traffic school in addition to that. The good news about that is for traffic court, it's not criminal. I can go for you, I can represent you in traffic court, and you never even need to worry about it. Thank you.